Hi everyone, welcome to Legal Talks by Desi Kanun. I am Suyash, currently working as an advocate, a podcaster, a blogger, and a YouTuber. I have been practicing law since last 6 years in India, and of late I have involved myself in content creation. So let us get on with the show and discuss the case at hand. On today's show, we will discuss another judicial pronouncement by the Honorable Supreme Court of India, namely Neeharika Infrastructure Pvt Limited versus State of Maharashtra and others, 2021 SCC OnLine SC 315, wherein certain important questions relating to a petition under Section 482 of the Code of Criminal Procedure for quashing of FIR or criminal proceedings were discussed. What is Section 482 of CrPC? It provides for the inherent powers of the High Courts and states that the High Courts have the power to make such orders as may be necessary to give effect to any order under this code, or to prevent the abuse of process of any court, or otherwise to secure the ends of justice. In the present case, an interim order was passed in a Section 482 petition by the Bombay High Court directing that no coercive measures shall be adopted against the accused in respect of the concerned FIR. Such interim order was challenged before the Supreme Court in the present case, and the Supreme Court deprecated the practice of granting blanket interim orders in Section 482 proceedings, thwarting the undergoing criminal investigation. Thus, the Supreme Court passed certain guidelines and directions that are to be followed in all the cases wherein the High Courts exercise jurisdiction under Section 482 of CrPC or under Article 226 of the Constitution of India that provides for writ jurisdiction. The facts of the case are not important, hence we are not referring to them. Now let us discuss the directions of the Supreme Court in the present case. They are: firstly, it was observed that the police has the statutory right and duty under the Code of Criminal Procedure to investigate into a cognizable offense. Secondly, the court mandated that an investigation into cognizable offenses must not be thwarted in Section 482 petitions, and only where no cognizable offense is disclosed in the FIR that the court can quash the FIR or criminal proceedings. Thirdly, it was opined that the power of quashing should be exercised sparingly with circumspection, as it has been observed in the rarest of rare cases. Fourthly, it was directed that while examining an FIR or a complaint, quashing of which is sought, the court cannot embark upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR or the complaint, and the criminal proceedings must not be quashed at the initial stage. Fifthly, the Supreme Court observed that the courts should not usurp the jurisdiction of the police, and rather they should complement, not overlap the functions of the police. Sixthly, it was laid down that the judicial process may interfere at the stage of investigation of offences where the same would result in miscarriage of justice, and such power must not be exercised whimsically. Seventhly, it was directed that when a court exercises the power under Section 482 of CrPC, it only has to consider whether the allegations in the FIR disclose commission of a cognizable offence or not. The court is not required to consider on merits whether or not the merits of the allegations make out a cognizable offense, and the court has to permit the investigating agency or the police to investigate the allegations in the FIR. Eighthly, the Supreme Court noted that an interim order of stay of investigation during the pendency of the quashing petition should not be passed routinely, casually, or mechanically. Without having sufficient material on record in 482 petitions or Article 226 petitions, the High Courts shall restrain themselves from passing the interim order of not to arrest or no coercive steps to be adopted, and the accused should be relegated to apply for anticipatory bail under Section 438 of CrPC before the competent court. Ninthly, it was further laid down that in cases where the High Court does form an opinion that an exceptional case is made out for grant of interim stay of further investigation, it shall provide brief reasons in the said interim order demonstrating application of mind, and in case the interim order is of the nature no coercive steps to be adopted, then the High Court shall clarify the contours and the meaning of no coercive steps to be adopted, since such term is broad and vague, susceptible to misinterpretation. And lastly, the court observed that an FIR is not an encyclopedia that must disclose all facts and details about the offense, and often it is premature to conclude based on such hazy facts that the FIR or the complaint does not deserve to be investigated. In any case, when the investigation concludes, there are other remedies available with the accused to get exonerated. Therefore, in the present case, the interim order that directed that no coercive measures to be adopted in the 482 petition was set aside by the Supreme Court. This was all about what was held in this case. So, what are my concluding remarks? Every few months or so, a case comes up before the Honorable Supreme Court wherein it is constrained to observe that the powers under Section 482 of CrPC must not be exercised lavishly and without application of mind. The legislature has enacted Section 482 to provide powers to the High Court to prevent abuse of process or do justice. But as the court rightly pointed out, this does not mean that the High Courts would take up the role of an investigator and start appreciating the evidence in a selective manner. By this judgment, the Supreme Court has not curtailed the powers of the High Courts. Rather, the same have been aligned keeping in mind the principles of natural justice and the role of the police in investigation. I hope that these directions serve as a beacon of light to the High Courts all over the country, and Section 482 is entertained or invoked only in appropriate cases. Thus, I hope you enjoyed listening to this show. Thank you for listening. Please do not forget to like and subscribe us, and if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.